morning, everyone. I'm Dov, and together with Louis, we are going to be talking today about the new fixed costs regime. Louis is the junior tenant at Radcliffe Chambers. He joined us last year. He has a busy practice, and a lot of that is in the county court and dealing with the sorts of matters which will come within the new fixed costs regime. And we've worked closely together on bits and pieces over the last year or so while he's a junior tenant. So welcome, everyone. It's great to see so many of you here. I'm going to hand over first to Louis. Could you give everyone a general overview of the background to the fixed cost regime?
Sure, thanks very much, Dov. So the genesis for these reforms is, as you will probably know, Sir Rupert Jackson's review of civil litigation costs back in 2010. And those reforms were really driven by a desire to do two things. First, to impose discipline and avoid runaway costs. The concern is that if your expectation is that the losing side will pay, and that the more costs you incur, the more likely you are to win, you have every incentive to run up completely disproportionate bills of costs. The second concern is to give parties certainty about what costs they'll incur if they win, but what costs that they risk paying also if they lose. Now, in Sir Rupert Jackson's sort of world, you can control recoverable costs in two ways. You can have a scheme, a general scheme of fixed recoverable costs with grids telling you exactly how much you can recover for each stage of the litigation. Or you can impose, as has now been done, cost budgeting. So you impose at an early stage a binding budget negotiated by the parties, but subject to the oversight of the court. Now, cost budgeting is a less effective way and a less stringent way of controlling costs because it itself has process costs, and it doesn't really give the court oversight over incurred costs, so really anything incurred pre-CCMT. Now, the scheme of fixed costs, which Sir Rupert Jackson set out, is the stricter solution, and that's what he recommended in 2010 across the fast track. Now, that recommendation wasn't taken forward in that form. It was implemented in respect of personal injury cases, but not in respect of non-personal injury fast track cases. So these reforms really finished that work. And there was a strong push particularly from the senior judiciary to extend the regime, the fixed recoverable cost regime, so you have a grid of costs which tell you exactly how much you can recover in advance, to other categories of case. And that's what Sir Rupert Jackson's further report from 2017 was all about. And he's now recommended a very significant expansion of the fixed recoverable cost regime. Essentially, for most civil cases, there are some exceptions which we'll talk about, all the way up to £100,000. And the government has carried out a consultation on those proposals, and it's settled on the broad picture of the reforms which it's going to implement soon. I should say there are still consultation documents coming out as late as a few days ago. So this is the broad picture, but it's very much subject to change. Now, the response from the industry has been pretty negative, I have to say. So both the Law Society and the Bar Council are opposed to the expansion of fixed recoverable costs in this way. The Law Society has said essentially that it's concerned that the proposals are based on insufficient and potentially outdated data and flawed assumptions. For example, that solicitors would set fees equal to the fixed recoverable cost which could be recovered, which they say is plainly not the case. And the Law Society says that instead of expanding the regime, we should focus on streamlining processes to reduce the actual costs of litigation. Bar Council is also opposed to the reforms in their proposed form, at least. And the concern there is that the expansion is premature and that the existing fixed cost regimes suffer from a number of problems. In particular, out-of-date fees and the absence of any cost provision where cases settle late. That's something which the government is now, I think, wanting to consult on as well. The view from industry, unsurprisingly, is more positive. The Federation of Small Businesses had argued that there should be a much greater expansion of the fixed recoverable cost regime for commercial cases of up to £250,000. And its refrain there is that there is an urgent need to reduce the cost of going to law for small businesses. So that's really the background. And Dov, I think now you're going to explain how the new regime is going to work.
Yes, I mean, despite all the misgivings of the Bar Council and the Law Society that there is insufficient data and the numbers aren't right, and the fact that the government is still sending out documents, I think the most recent I've seen on the consultation from the Ministry of Justice was only 2 days ago. The scheme is going to come into force, and it's going to come into force for most things on the 1st of October of this year. There's some exceptions in relation to personal injuries, where it won't apply except where the cause of action arises after the 1st of October, and also in relation to disease claims where the letter of claim hasn't been sent prior to 1st of October. But for general civil litigation, certainly anything that's going to come to through Lincoln's Inn and a chancery set like Radcliffe Chambers, or commercial work, we're looking at a 1st October 2023 start. We're then looking about what is the general scheme. Well, firstly, fixed recoverable costs is expanded across the whole of the fast track, rather than just having part of the fast track having a fixed recoverable cost regime, as is currently the position. And secondly, and significantly, there's going to be a new track, a new intermediate track that is established for simpler cases that fall outside the fast track, previously would have come within the multi-track, but from October will be treated as a special intermediate track between the fast track and multi-track cases. The multi-track threshold, rather than being £25,000, as is currently the position, will move up to £100,000. So we've got the 4 tracks. We've got the small claims track, generally for stuff under 10,000, the fast track, the intermediate track, and the multi-track. There's certainly a lot of relief among practitioners that the fixed cost regime stops, more or less, at the £100,000 level. The original proposals a few years ago, even before inflation, had suggested 250,000 as the threshold for leaving the fixed cost regime, but we're at £100,000. There are a number of exceptions. It's not going to be a blanket policy that applies for everything. There's certain exceptions relating to things like clinical negligence, which are subject to special regimes. Housing claims, they are currently outside the proposed fixed cost regime. That includes possession claims. There may be further reforms on that. The fixed costs regime does not apply to Part 8. Part 8 is going to continue to result in allocation, or a standard allocation, to multi-track, although of course the courts always can have a discretion and move things from the multi-track. Insolvency proceedings as well, they are going to default to the multi-track. There has been a suggestion that some of the more straightforward things that go through the insolvency proceedings, such as company restorations, will be the subject of particular rules and provisions. That hasn't happened yet, but that may be something that's in the pipeline. So when dealing with a case, the first decision that needs to be made, first consideration, is the allocation to track. How do you decide which track a case is allocated to? Well, the principal determinants of the normal track are threefold. Firstly, you look at the value. Secondly, you look at the length of the trial. And thirdly, you look at the extent to which expert evidence is required. So for the fast track, that's the normal track for claims up to a value of £25,000, and where the trial is likely to last for no longer than 1 day, and oral expert evidence is going to be limited to 1 expert per party in any field and no more than 2 expert fields altogether. Above the fast track, you have the intermediate track. It's handily defined as a track which is suitable for cases which are neither suitable for the small claims track or the fast track, with a value of up to £100,000, where the trial is not expected to last longer than 3 days, and oral expert evidence is limited to 2 experts per party. Normally, in the intermediate track, you're not going to have more than 1 claimant against 2 defendants or 2 claimants against 1 defendant. There's further detail of the criteria, but that's generally the rough scheme. So critically important, the duration of the expected trial and the value. There are not that many cases that are going to have more than 2 experts fields to be considered, which aren't going to be, which are going to be modest cases and need to be considered. There is a residual discretion. The scheme is capable of some flexibility. The intermediate track is described as the normal track, only where claim can be justly and proportionally managed by the intermediate track procedure, and where there are no additional factors which make the case inappropriate for the intermediate track. Similarly, it's possible to allocate complex cases which are valued at under £100,000 to the multi-track. So you're not tied into the intermediate track if there's a complex case, even if there's the value is a little bit under 100,000. Similarly, it's possible for cases to go into the intermediate track where it's considered in the interest of justice to do so. So that can be a case which is boosted up from what might normally be a fast track procedure, or pushed down from a multi-track type procedure. So there is flexibility there. The court will have regard to the allocation factors set out in what is proposed to be the new CPR Part 26. So you've got the value, the complexity, the nature of the remedy, the number of parties, and so on. The process for this is that it's envisaged that there will be a decision on allocation, which will normally be done on the papers by the court once the court has the statements of case and the allocation questionnaires. But if there are differences between the parties as to which is the right track, or there's some uncertainty, particularly as to value or trial duration, that sort of thing, then there can be an allocation hearing. Once the case has been allocated to a track, there is a power of the court to reallocate to a different track if circumstances require. However, the rules emphasize that this is only to happen if there are exceptional reasons for doing so. So it's not going to be a routine situation where cases put in the intermediate and then moves up to multi-track, or vice versa. There've got to be exceptional reasons. So perhaps a claim which is thought to be of modest value, suddenly something happens and the value massively increases. Or perhaps the reverse, the claim starts, it's defended, it seems to be a very substantial value, and then concessions are made and so forth, and the issues narrow, and it ends up being a much simpler piece of litigation. Perhaps that might be an exceptional reason. No doubt there'll be case law coming out over the next few years as to what counts as exceptional. But it's certainly not going to be routine. There are some complexities as to what's going to happen if you have a claim which involves non-monetary relief. By definition, non-monetary relief does not have a financial value. It would normally be allocated to the fast track if the trial's not going to last longer than a day and you don't need more than 2 experts. and there is no associated monetary relief over 25,000. In other circumstances, it will go either to the intermediate track, unless the court considers that, if the court considers that's in the interest of justice. Otherwise, it goes to the multi-track. Obviously, non-monetary relief injunctions can range from the most trivial of matters to the most serious. So the court will exercise some flexibility when considering non-monetary relief cases. So that's how the allocation process works. Now, Louis, can you give an overview of the provisions dealing with the sorts of directions and case management that we're likely to see?
Sure, thanks. So first big change introduced by the introduction of the intermediate track is that you will now, by default, in an intermediate track case, have a case management conference. And the court may also fix a pre-trial review. And this is in the new CPR Part 28. Whereas in the fast track, as currently, a case management conference will not normally be held, but the rules contemplate that it may be held, for example, where the court has been unable to give directions without the need for a hearing. Now, as under the existing rules applicable to the fast track, there's a very strong incentive or drive for the court to give directions wherever possible without the need for a hearing. The new practice direction accompanying Part 28 also envisages that standard form directions will be published for cases in the intermediate track, but those, it seems, aren't yet available. We'll look to circulate them when they are. But on top of these standard form directions, which are awaited, the new CPR Part 28 imposes some compulsory directions which apply in intermediate track cases. And so this is a new CPR Rule 28.15. There are two compulsory directions which the court must make. First, oral expert evidence must be limited to one expert, one witness per party, except where the oral evidence of a second expert for any party is reasonably required and is proportionate. And the second compulsory direction is that the trial time estimate must not exceed 3 days. Now, these are included as compulsory directions, but really they just reflect the criteria for inclusion of this case, this hypothetical case, on the intermediate track. On top of this, still in CPR Rule 28.15, you have standard directions which the court will make, but which it can disapply. And there are three. First, in respect of disclosure, standard disclosure is not the default option, except in personal injury claims. Now, the court has to choose from a menu of options ranging from an order dispensing with disclosure up to standard disclosure and various levels in between, having regard to the overriding objective and the need to limit disclosure. There's a very strong sort of push to limit disclosure to that which is necessary to deal with the case justly. Secondly, the total length of all the permitted witness statements and witness summaries, total length of all the witness statements cannot exceed 30 pages, which is a pretty stringent limitation, but again, it can be disapplied. And thirdly, any expert report cannot now exceed 20 pages, excluding any sort of photographs, plans, appendices, and so on. So Dov, I think now you were going to show us how the regime will work using perhaps a few sort of examples.
Yes, thank you. So where the court allocates a claim to the fast track or to the intermediate track, it will also assign the claim to a complexity band within that track. And this is the chief determinant of the amount of fixed costs that will be recovered pursuant to what's going to be the new Part 45, when you coordinate the band with the stage that the case has reached. So what's been provided are slides, are tables, which we've conveniently, hopefully, managed to put into a slide for you. And there are, firstly, different bands for the fast track, and you can see how from complexity band 1 to complexity band 4, they're the different levels. So 4 is the most complex of the fast track cases, and this will have a knock-on impact on the amount of costs that are recoverable. So basically less complex in band 1, more complex as you go up through the bands up to 4. There is also a similar table for the intermediate track. Fantastic, it's come up on screen. And complexity band 1, if there's only one issue in dispute, you're only going to have a one-day trial, up to complexity band 4, where you'd have a number of issues in dispute, and you're looking at a trial of, say, 3 days. So you go through those bands. And obviously, it's a bit of a judgment call where you fit, and there are no hard boundaries between these particular bands, less complex, more complex, and so forth. The basic scheme is then that you have to look also not just at the bands, but also at the relevant stages. And there are tables of the various stages the cases come to. So there is a table here of stages in the fast track, and at each stage you can read across for the complexity band. So if you are looking, you can see how much is paid for reaching a particular stage on a particular banded case. And there's a similar table for the intermediate track, and we're going to look at this in a little bit more detail with the intermediate track. So first thing to note on this is the stages. So stage 1 is from pre-issue up to and including the date and service of the defense. So that is a stage which is defined by a point in time, 2 points in time, from pre-issue until service of the defense. If you look at stage 3, it runs from the date of service of the defense up to the earlier the date set for the CMC, or the date of the order giving directions. And then stage 4 again is a chronological stage, runs from the end of stage 3 up to the date for the inspection of documents, and so forth. So you can see some of the stages are chronological. Those of you who are focusing will have noticed that I missed out stage 2 there. Stage 2 is not a chronological stage. Stage 2 is specialist legal representative providing post-issue advice in writing or in conference, or drafting a statement of case. Similarly, if you look at stage 7, it's for a specialist legal representative advising in writing or in conference following the filing of a defense. So stage 2 and stage 7 are really add-ons. They are not chronological stages. So there's a little bit of inconsistency in how this is presented, but the end result should still be comprehensible, because you work through the chronological stages, which don't include number 2 and number 7, and then you'll add on the extra costs incurred if you do have the specialist legal representative providing advice under stage 2 or under stage 7. Some stages might not happen in some cases. So for example, stage 4 runs from the end of stage 3 up to and including the date set by the court for inspection of documents. You might have a case where there has been no date set for inspection of documents because no disclosure is required. The parties might have already had the relevant documents, they might have exchanged them, there may not need to be any disclosure. So in that case, you wouldn't have a stage 4. Another oddity about this table is if you compare the figure under stage 2, under, for example, complexity band 1, for the specialist legal advice providing post-issue advice, specialist legal representative providing post-issue advice. There's a figure of £2,000 for advice there. At stage 7, providing advice is a reduced figure. It's £1,400. So they've obviously considered, the draftsman of this table has obviously considered that the timing of the advice will impact on the amount of the fixed recoverable costs. And this, I assume there's been consultation and thought gone into this, but it's clearly inappropriate in some cases to assume that later advice is going to be likely to cost less than earlier advice. But anyway, those are the oddities. How will this actually work in practice? Well, let's put forward an example of a claim for £75,000, which is expected to last, say, no longer than 3 days, with 2 experts per party in 2 different fields. So if it's a £75,000 claim and it's not going to last more than 3 days, that can squarely fit in the intermediate track. So now you bring up the table that we've got on screen, you decide what's the complexity band. Well, it's more complex than the most basic. Let's say it fits within complexity band 3 because there's more than one issue in dispute. This hypothetical case then settles after the case management conference, but before the date which is set for disclosure. So that means we need to look at stage 4, which is the stage which runs up to the date for inspection. And because we're in complexity band 3, we're looking now at the highlighted box, and in that highlighted box, the amount to be paid is £11,000. The case, this hypothetical case, settled for £60,000. So in addition to the £11,000, there is also a percentage, a 14% of the £60,000 agreed damages. So 14% of 60,000, mental arithmetic, 8,400. Add to the 11,000, the figure that one receives by way of fixed costs is therefore 19,400. If there was advice in conference from the intended trial advocate, for example, following filing of a defense, you can add a further 2,300 under stage 7. In addition, if there were any reasonably incurred disbursements, such as, for example, an interpreter or something of that sort, that would be an extra which comes outside of this table. So that gives you an idea of how to calculate the fixed cost for a case that settles, or indeed one that doesn't settle. You can compare that example to a claim which proceeds to trial. If it proceeds to trial and damages of £60,000 are awarded, you're now looking at stage 8, from the end of stage 6 up to the date of the trial. So you've achieved success. You have a figure of £19,000 plus an amount equivalent to 20% of the damages. Note the difference between settlement at the earlier stage, where there was going to be 14%. You get a greater percentage of damages if you get them at trial, which is an incentive on defendants to settle. So £19,000, 20% of the damages, 20% of 60 is 12,000, so that makes £31,000. Assume the claimant prepared the trial bundle, otherwise you've got to deduct 1,120. If the trial lasted 3 full days, you add a fee for the attendance of the solicitor per day, that's stage 9, of £1,200 for each of the 3 days, that's 3,600. And you add advocacy fees you've got an advocacy fee for day one, 4,000, and then you add for each subsequent day, stage 11, £2,000, and there are 2 subsequent days. So the advocacy fees is £4,000 for day one, plus 2 times 2 is another 4, is 8,000 there. If there's a subsequent hearing for consequential matters, perhaps an application for permission to appeal or something like that that needs to be dealt with, an extra £580. All that will come to 43,180. There might be some extra disbursements. There may be some optional extras if, for example, there needs to be, if there's been, for example, some ADR and there's some pricing for fixed costs for ADR as well, if that occurred. But that gives you an idea of how the scheme actually works in practice. So, Louis, what are the significant features of the scheme that you think are likely to arise in practice and we really ought to know about and think about?
Thanks, Dov. So the rules contemplate, they make provision for a few of the sort of more technical things which will happen in litigation and which will have a bearing on costs. So what I'd like to run, I'd like to run through a few, I think, notable features and just sort of tick them off quite quickly. So first of all, what happens? How do you calculate your fixed recoverable costs where you have a claim for non-monetary relief? It's still necessary in that situation to allocate a notional value to that relief for the purposes of calculating the fixed costs that you can recover. And the approach taken under the new scheme is to determine those values according to the complexity band assigned to the claim. So, for example, the non-monetary relief values are fixed for fast-track claims in a table at it's at rule 45.45, and the values go up according to the complexity band. So if you have a non-monetary relief claim and the claim is allocated to complexity band 2, the notional value of that claim for the purpose of calculating your fixed recoverable costs is £10,000. If your claim is allocated to band 3, £15,000, and so on. For the intermediate track, it works in exactly the same way. So if you have a non-monetary relief claim, your claim is allocated to the intermediate track, and the claim is allocated to complexity band 1, the notional value of your non-monetary relief claim is £25,000. If your claim is in band 2, £50,000, band 3, £75,000, and band 4, £100,000. So this is, to be clear, this is just for the purpose of calculating your fixed recoverable costs where you have a claim for non-monetary relief. Now, if you have both a claim for monetary relief and non-monetary relief, you add both. So you calculate your fixed cost by reference both to the damages awarded on your successful monetary claim and the assigned value for any claim for non-monetary relief. So that's claims for non-monetary relief. The next point I'd like to cover is counterclaims, which is where I think interesting points can arise. So that the basic position is that in principle, you can recover 2 sets of fixed recoverable costs where a defendant is successful both in defending the claim and in bringing a counterclaim. The condition, though, is that the only remedy sought by the counterclaimant is not also a defense to the claim. That's the condition you have to meet to be able to recover the costs of your counterclaim as if it were a separate claim. If that condition is met, so the only remedy you're seeking is not also a defense to the claim, your counterclaim is treated as if it were a claim. And so those costs are recoverable in addition to those which the defendant would be entitled to as a result of successfully defending the claim. Now, I think that this is exactly the type of area which will give rise to argument. So if you assume for a moment that you're sued for damages and you counterclaim for an injunction, that could, in principle, without more, meet the test. In your counterclaim, you're seeking as your only remedy something which is not also necessarily a defence to the claim. But assume you're sued for damages and you counterclaim for an amount of damages to be determined, you don't know exactly what it's going to be yet, and the court determines those damages, concludes that they exceed the value of the claim against you. Is that a counterclaim which is not also a defence to the claim? Probably on these facts it might well be, so that you can't recover the costs of your counterclaim separately to the cost of your defence. In reality, though, what I think these examples show when you start to think about them is that you can't actually give that much general guidance in this area on this particular point, because in these types of situations, the answer will depend heavily on the nature of the counterclaim and the facts giving rise to it, which is exactly why I think this is going to be an area where parties will be in dispute, because the implication is potentially quite significant. It means that you have this whole other set of fixed recoverable costs that you add to the cost of your defence. And the rules, which are shortly stated, are at new 45.7. Now, moving on, where you have multiple claimants represented by the same solicitors, and each claimant has a separate claim against a defendant, and the claimants win, and they get a costs order, it may turn out that the court orders that the claimants are entitled to only one set of fixed costs, calculated by taking the cost payable to the claimant who gets the most damages, to which you add 25% of those costs for each additional claimant. And that generates a pot of money which the claimants represented by the same representatives would effectively have to share. And that's at new CPR rule 45.5. A few other points to note. Specific provision is made for preliminary issue trials. So if you have a trial on a preliminary issue, the basic rule is that it's treated entirely separately. So, for example, if a claimant succeeds on a preliminary issue, a cost order is made in their favour, that party will be entitled to the fixed costs for the stage reached when that issue is determined, if necessary, all the way up to the trial of that preliminary issue. And if that claim then continues, following the determination of that preliminary issue, they will be entitled to whatever additional costs they incur in the proceedings, additional fixed costs that they incur in the proceedings. The costs I should flag of pre-action and interim applications are also fixed. And what's striking is that they're fixed at what really seems to be a very low level here. So, I mean, there's some banding, depending on the complexity and the type of application, but the most you can get, and this is for a successful summary judgment application, is £750, which strikes me as pretty low. Just a final few points to tick off quickly. If you have a litigant in person and a cost order is made in favour of a litigant in person, the basic rule is that their costs, the cost which the litigant in person will be awarded, are capped. And they're capped at 2/3 of the fixed costs that they would have got had they been represented. There's also an uplift, what they call London weighting, where a party lives or works in London and is represented by London-based solicitors. In that situation, you get a 12.5% uplift on any fixed costs which are awarded. And the final point I want to cover are some of the boundaries of the regime. So first of all, protected parties. The fixed recoverable cost regime in Part 45 doesn't apply at all, where any party is a protected party. The first point. The second is that the court retains a power to award an amount of cost greater than the fixed recoverable costs, where there are exceptional circumstances making it appropriate to do so. And Dov touched on this earlier. No doubt there'll be case law in due course. Probably this will be very narrowly interpreted. And this is a different point I should flag to the court's ability to penalise a party in costs for unreasonable behaviour, which I think we'll come on to. Finally, and Dov touched on this earlier, also disbursements are effectively carved out of the fixed regime. in that the court will allow any disbursement which has been reasonably incurred, both in the fast track and in the intermediate track. So those are some of the points in Part 45. Some of them are quite technical. Some of them are going to require, I think, a bit of case law to be properly worked out. But those are the things which I think were useful to flag at this early stage. So we now wanted to turn to some of the points of interest, of greater interest perhaps, and uncertainty which were raised by the regime. Dov, what were the points that you wanted to flag here?
Well, I wanted to pick up on what you were saying about unreasonable behaviour. Historically, we're comfortable with the idea that if a party has behaved unreasonably, they might be deprived of some costs, maybe all costs. They may have an indemnity costs order against them. And with these reforms, there's an inclination to avoid indemnity cost orders, because then you're going into the whole process of assessment and uncertainty and so forth, which contradicts the main thrust of having a fixed cost regime. There is a sanction. There is provision in the proposed rules that where a party has behaved unreasonably, the other side, if the other side is receiving costs, can have an uplift of 50% on their costs to reflect their success and the fact that the paying party has been unreasonable. There's also a provision that if the receiving party has been unreasonable, then their costs can be reduced by 50%. What strikes me as slightly odd is to have this provision which says the costs can be reduced by 50%, rather than having a provision which says they can be reduced up to 100% reduction. It seems that the court's powers to deprive a party of costs in their totality still exists under the general rule that costs are generally payable to the successful party, with exceptions there. But the specific rules for fixed costs only refer to a reduction of 50% for unreasonable behaviour, or a bonus of 50%. The other area which was very contentious when these rules were being formulated is what's to happen in relation to Part 36. Now, Part 36 obviously is something that encourages a lot of cases to settle. The judiciary are very keen on cases settling. It makes the court lists rather shorter. And there were two schools of thought. One was, well, if you beat a Part 36 offer, then the current regime should more or less continue, and there should be scope for indemnity costs if you are a successful claimant. Again, under the new regime, that was not adopted because it would lead to assessments and uncertainty and so forth. So if you are a successful claimant, then you can have, and you make a Part 36 offer and you beat your Part 36 offer, then the claimant would, in general, get an uplift of 35% on the fixed costs that would normally be calculated for them. So there is a fair amount of certainty, and you can read across the table, see what the fixed costs are, and then uplift by 35%. So relatively straightforward. The fact that the paying party can pretty much calculate what their cost exposure is may discourage paying parties from making offers, because they might say, well, actually, the worst case scenario is, and then they look at the relatively ungenerous costs that are allowed on the fixed cost regime, add another 35%, and they think, well, okay, they might decide to take their chances at court. That's obviously the flip side of reducing the amount of costs that a party can recover. It encourages litigation to continue. So there is a tension there very much throughout these rules between reducing the costs as far as possible and reducing the amount of litigation that goes in front of our judges. So those are a couple of thoughts that I've had. I mean, Louis, have you thought of any other points of interest or uncertainty that you anticipate that people might want to hear about?
Sure, thanks, Dov. So the point that I think is interesting here, most interesting, is whether the new regime cuts across a contractual entitlement to costs, one, and whether, two, you can contract out of it. So it seems, as the law currently stands, that the new regime won't cut across a contractual entitlement. So you'll probably be aware that where you have a contractual entitlement to costs, Rule 44.5 of the CPR applies, and the court will normally make an indemnity costs order unless the contract provides otherwise, and that reflects the underlying substantive law. And so the leading case here is still the Court of Appeal decision in Chapler Holdings and Kumari, which makes clear that although an order for the payment of costs is always discretionary, where there is a contractual right to recover costs, the discretion should normally be exercised so as to reflect that contractual right. And this is something that Sir Rupert Jackson was very aware of, or was very alive to in his 2017 report. And he states that, you know, in his view, there's nothing in the rulemaking powers to make the CPR which can exclude or override a contractual entitlement. And in his view, primary legislation would be required to alter that position. So he expressly said that nothing in the reforms he proposed should affect the question of contractual entitlement. Now, I think that does reflect the position in the new rules, which aren't, I should say, I mean, that they've been developed and carried forward after consultation. So what Sir Rupert Jackson said isn't necessarily the last word on this. But I can't see anything in the new regime which would cut across a contractual entitlement to costs. So it appears that if you have a, you know, typically in a lease, for example, an entitlement to recover your costs, you can still rely on it. I should say, though, that there is, I think, room for the law to evolve here. And the thing to bear in mind is this point in Chapler that a cost order is always in the discretion of the court, even where you have a contractual entitlement. And so what I can imagine, although this, I should be clear, isn't yet reflected in the authorities, is that if you have a move towards fixed costs in an ever-expanding category of cases, which is a very clear sort of policy decision by the government and supported by the senior judiciary, I would expect, I wouldn't be surprised if the courts started to be more reluctant in time to exercising their discretion to reflect contractual entitlement, where the effect of that would be to take you out of the fixed cost regime. But to be clear, we haven't seen that yet in the authorities. That's just a possible direction of travel. I just don't think the things aren't fixed here yet. Now, a different question which may arise is whether it is open to parties to contract out of the fixed cost regime. And this matters because I think there is a risk that you can contract out unwittingly. And the current trend of authority here suggests, again, that you can contract out. There was a recent case in the Court of Appeal called Doyle and MD Foundations and Building Services. And this was a claim which involved, it was an appeal concerning a claim subject to the protocol on low-value personal injury. So it's a claim which is subject to an existing fixed cost regime. And there, the parties had entered into a consent order by which the defendant agreed to pay the claimant damages of £5,000 in respect to a personal injury, provided that the defendant was to pay the claimant's costs, which were, and the agreement in the consent order was such costs to be the subject of detailed assessment, if not agreed. And the question was whether the effect of that provision was that the parties had agreed to contract out of the fixed cost regime. And the Court of Appeal held, one, that they could contract out, and two, on the facts that they had. And it confirmed that the fixed cost regime can be disapplied by agreement, and that an order providing for detailed assessment without more necessarily entails an assessment on the standard basis. And that necessarily takes the case out of the fixed cost regime. So as matters stand, I think not only can parties contract out of the new regime if they choose to do so, I think there is some risk that they could unwittingly be found to have done so, where that on its proper construction is the effect of their agreement. So that's a particular point to be wary of, particularly in negotiating settlements. Two further quick points which arise out of the government's latest consultation document, which came out just a few days ago. There are 2 points I'd like to make. One is that the government's announced that the tables of fixed recoverable costs, which we looked at earlier, will be increased to account for the current level of inflation. And the new figures will be in place, they anticipate, in April 2024. And thereafter, they'll be reviewed generally every 3 years. And another point which the consultation document envisages is that it wants to introduce a specific regime, itself subject to fixed recoverable costs, for determining disputes about what fixed recoverable costs are payable. And so you will have seen from some of the points we raised earlier that there is a lot of scope for dispute about what fixed recoverable costs are payable, which can itself lead to satellite litigation. And so what the government now envisages, but this is at an early stage out for consultation, is that the parties would obviously attempt to agree informally, failing which they could make an application to the court or issue new Part 8 proceedings to be determined initially on paper, but with some provision for an oral hearing, which is slightly complicated, with the costs of that determination to follow the event and to be capped at £500. So in other words, this stuff is moving, and the government is conscious of the risk of satellite litigation, but it's trying to introduce fixed recoverable costs at every stage of that process. That's all I had to say. Dov, I don't know whether there's time to take any questions.
Yeah, we've got a few questions on the chat. As I can see, we've been going almost an hour. So we'll just have a look at some of these, and I think where we can give some prompt responses. So the first one, I'm not gonna name the questioners. The limit of pages of evidence, can you shrink the font size? No, the judges will throw it back. Certainly you've got limits on page length for skeleton arguments in the Court of Appeal and under various different practice guides. And if you don't provide it in 1.5 spaced lines and 11 point and so forth, you get these things thrown back. So you can't fudge the limit on the 30 pages of evidence. I think I can deal with the next one as well. The next question is, are these costs cumulative or per stage, if that makes sense? So on those tables, I don't know if you want to call back up the table, Louis, if we've got that to hand, and you can just see that you just read across from the stage that you've got to. And you add, so if you go to the trial, you add, so if you're on the trial costs on a complexity band 2, and it's at trial, you get 17,000. You don't get 17,000 and then add back everything from stage 1, 2, 3, 4, 5, 6. But you can add the extra, the supplemental things, such as for ADR. So some are cumulative, but on the whole, you get to the stage and that's the amount. The next question is about insolvency. I think my recollection is that the insolvency cases will all be outside of this regime.
Yeah, so how it works with insolvency is effectively the insolvency rules provide that insolvency proceedings, which is a defined term in those rules, are allocated to the multi-track, and nothing in this new scheme cuts across that. So the question is whether the insolvency exception would encompass Part 7 claims which arise from insolvency, for example, a claim by a company in insolvency, or only specifically insolvency applications under Part A's. It's a good. I think the basic answer will depend on the interpretation of insolvency proceedings and the insolvency rules. But if you have what is a normal Part 7 claim, say for damages, which you wouldn't fit into the definition of insolvency proceedings, it would, without more, be caught by the new fixed cost regime.
Yeah. So if it just happens to be that the claim's brought by a company which is insolvent, but it's not a claim against a director for misfeasance or anything like that, it's just for a refund of the electricity bill or something like that, it could be dealt with under the fixed cost regime.
That's right.
The next question, what else have we got here? Somebody's asked, has there been any suggestion about how the new rules might apply to something like defamation cases? These often have a lower monetary value, but can be serious or complex. It doesn't appear that there is any exclusion, so presumably this will be dealt with on a case-by-case basis. I confess defamation is not the bread and butter of my practice, but I haven't seen any reference to defamation. There are exclusions for, I think, cases which could go to a jury trial. I'm not sure how many jury trials are left in defamation cases these days. But if it's something that's a serious matter to deal with, reputation and so forth, it might well justify a multi-track allocation if it's a serious thing, even if it's low value. But it is case by case, I would have thought. Somebody has asked a very sensible question: are amounts inclusive of VAT? I'm not sure I've seen mention of VAT on any paperwork. I had assumed that it's exclusive of VAT, but I confess that I haven't checked that one. Any ideas, Louis?
I think they are exclusive of VAT, and so there's provision, I think it's at 45.2, which provides that where appropriate, VAT may be recovered in addition to the amount of fixed costs.
Perfect, thank you. Part 20, practice direction 28. Do you need to formally apply to disapply the standard length of witness evidence? My instinct, well, depends how much you're going to breach the rules, and when it's going to be apparent. It might be something that you deal with if you know you're going to be serving a 200-page witness statement. I'd certainly ask for permission at an early stage, because you wouldn't want to have a line put through your witness statement or to be disallowed costs or so forth. If it's just a marginal thing, you might be able to deal with it at the trial.
And what I was going to say is I expect, so this is a direction which applies in intermediate track cases where you will have, as a matter of course, a case management conference. And so that would be a natural time to raise that type of issue.
Will there be anything from preventing solicitors agreeing to charge clients as usual, as long as clients are also advised appropriately as to the limits set on costs recovery? So there's no restriction on what solicitors negotiate with their clients. Obviously, clients have to understand that, as they're currently advised, that what they are charged is not the same as what may be recoverable, but there's no limits on charge out rates. Can you ever recover costs of an opinion from counsel pre-issue? The regime envisages that those sorts of costs are wrapped up in the stage one. So the costs are recoverable, but as part of the package of initial costs. It seems odd that it's encouraging the advice to come after the pleadings, where there's a separate line item for it, rather than at an earlier stage. But I think those costs come due. Is that how you read it as well, Louis?
Yes, I think that's right. And obviously you have specific provision I think it's at stage 3 for specialist advice.
Yeah, the two say yes. I think it's 2 and 7, isn't it? You get special advice later, but the question is about why there isn't that such a provision for pre-action advice. But that's an oddity of the rule. I think it's just encompassed in stage 1. The next question, did you say fixed recoverable costs would not apply to letters of claim issued before 1st of October? That's in relation to personal injuries. Disease claims only, there are exceptions, but for ordinary civil litigation, it applies to all claims after the 1st of October. What are we left? We're almost out of time now. We've done the hour. In relation to Part 36, is there any guidance on what regime will apply if, for example, Part 36 is made prior to the new regime, but proceedings are then issued post-October? I think if the proceedings are issued post-1st October, we're in the fixed cost regime, regardless of any Part 36 offer beforehand. Does the ADR allowance only apply to mediation? No, it also applies to settlement meetings. Do you not add in Section 2 and Section 7 to the cumulative figure? Yes, you do add Section 2 and Stage 2 and Stage 7 to the cumulative figure. They're add-ons if those are if there's been advice at those stages. And then again, somebody's asked about VAT. Is expert fee disbursement? Yes. Are all counsel's fees provided for in the stages? Yes. Again, I've been asked about stage 2 and 7. We've got loads of questions. We keep going now, but I think we've sort of covered most of the points. Anyone who still feels that they've got some burning issue that they want to get to the bottom of can ping an email. Louis' email and my email, I think, will appear on a slide as we switch off on this. But really, thank you so much. I can see we've had loads of you online, and best of luck coping with the new regime. Thank you.
Thanks very much.